Did you know that there are over 300 plus criteria that furnishers and credit reporting agencies must adhere to? That's right. There are more criteria for them to adhere to in order to even put information on our credit reports, and definitely to make sure that information is accurate. But most of us have no idea what that is. Well, I'm going to be discussing today some of those laws that the furnishers specifically have to adhere to. So let's get into it. Hey, this is Dominic Jackson, Coach D with Guaranteed Financial Consulting. And today we're going to be talking specifically about furniture. Now, again, a furnisher is, as we would say, someone like Capital One, for example, or Citibank, or Bank of America, American Express, Honda Financial, GM Financial, Mercedes-Benz Financial, anyone that's you are working with that they're furnishing information to the credit reporting agencies about us as consumers. These that I'm going to be discussing today are laws that they have to adhere to. Now, why is this important? Well, it's extremely important because if you don't understand what they have to adhere to, how can you address what may be inaccurate or could be wrong if you don't know what they have to do, right? So let's talk specifically about this thing. And I'm going to be taking it from the FTC. So this is the Federal Trade Commission. So they give oversight to this. So the Federal Trade Commission, the Consumer Financial Protection Bureau, or the CFPB, and the federal banking agencies, they all have the furnisher rule. And so it states they are identical in substance, okay? But what we're going to go through is a summarized version of the FTC. So let's get into it. Let's talk about accuracy. So when a furnisher reports information to the CRA, credit reporting agencies, some like to say credit bureaus, okay? But again, they're CRAs, credit reporting agencies. A furnisher, if they have any reason to believe that the information may not be accurate, it's actually illegal for them to report that information according to this FCRA, okay? One of the things that also says, now it doesn't mean if we as a consumer have told the furnisher that it's incorrect, but if they have reason to believe based on something in their system that is incorrect, it's illegal for them to report. And this happens, unfortunately. And that's a lawsuit. We can talk about all of that later. But it states in here, when it comes to accuracies, in the FCRA section 623A1C, okay? I'm reading it directly here. And it states that they cannot, under any circumstance, report information the consumer has told them is inaccurate if in fact it is inaccurate. That's an amazing statement. Again, that's the FCRA 623A1C is where it states that, okay? And again, these are summarizations, but I need you to understand the importance of these. These are the laws that they have to adhere to, not us. They do, okay? So let's get into some of the others here. Now, of course, we know that they must have written procedures and policies in place, okay? So that's part of the FCRA. They have to have written procedures and policies in place and how they handle things. But one of the things it says, I want to read this one to you because, again, it's one of those extremely important that often overlooked, but happens all the time. And so the FTC is telling these furnishers, this is what you have to do. These are the laws that you have to adhere to. Okay, so let's read this. It says that they have to prevent re-aging, meaning inaccurately changing the date of first delinquency on a consumer's account to a later date. That's what re-aging means. They change the date of the first delinquency. What does that mean? Let's say account goes into collection. The first payment that was late that led that account into collection or into foreclosure or into charge off or whatever that may be, okay? So you made a 30-day late back here in January, account gets sent to collection in September. January is the the date of last activity, not September when they send it to a collection agency, which oftentimes they like to change it. But if you make a payment and do those other things, they can re-age it. However, they cannot inaccurately change that date, which happens all the time. Now, let's discuss some specific items that we often find issues with as well when it comes to the credit reporting. A lot of times you'll see a credit card, you may find one that has a balance but doesn't have a limit. It's illegal for them to do that. So let's read through these again, okay? So, the furnisher's responsibility when it comes to credit limits. You must include a consumer's credit limit among the information you furnish to the credit reporting agency. So they cannot not report your credit limit. So if you find on your credit report that no limit is being reported, this is affecting your score. Why? Because credit utilization, as I've told you, is 30% of your credit score. And if you don't have a limit, but you have a balance, you're negative. And so it's dramatically affecting your score. And we could be talking hundreds and hundreds of points. So it's extremely important to look out for. Disputed information. Let's read about this. Of course, unbelievable, right? So once a consumer disputes information, you may not report that information to a CRA without telling the CRA that the information is in dispute. So if you or I dispute something on our credit report to the furnisher, so if we go to Capital One and we say, hey, this payment was never late, or hey, you're not reporting my limit, or it's incorrect. You say I owe this much and I don't owe that much. Okay. They have a responsibility, the law, that they have to let the credit reporting agencies know that the information is now being disputed. Of course, it doesn't happen, but it is the law. It is one of those requirements that they must adhere to. Now, let's talk about closed accounts. So if you or I decide to close an account on our home, okay, this is what they must do. If you furnish information to a CRA, again, as I've stated, we're talking about furnishers sending information to the credit reporting agencies. They must notify the CRA that the consumer has voluntarily closed an account the next time they report. Why? It's important because some users of information may interpret a closed account as an indicator of bad credit. However, if it's not clearly disclosed, consumer actually requested it be closed, not because of bad credit. And so why, again, are these things important? Because it's not all about the score. What's actually on your credit report? How is it being reported? Lenders and financiers, they don't just look at a score. They want to see the information on the report. How is it being presented? What's it actually saying? Did you close it because you don't want the account no more? Or did they close it because you were constantly not 30 days late, but 20 days late, and it just didn't get reported and they didn't want to do business with you no more? These things are things that they're looking at. So it's important to understand and keep in mind, if you close an account, it should state that you closed it, not that they closed it. So let's get into delinquent account. Now, there's a lot of information in this one, so I'm going to take my time and read through this because I want you to understand if an account goes into delinquency. So you're now 30 days late on an account, maybe 60 or 90 days late. These are the laws that the furnisher must adhere to when it comes to a delinquent account. So let's discuss this and talk about what the summarization of the FCRA states, okay? So if a furnisher account goes into collection, they have to notify the CRA that they have done so within 90 days of that account going into collection or delinquency, okay? The date of delinquency, hear what I'm saying, The date of delinquency is the month and year the consumer's delinquency resulting in the referral began. Again, this is what I told you earlier when it comes to date last activity. If you missed the payment in January, but they refer it in September, they have to report January, not September. So you need to make sure you're looking through that if you have any collections or delinquent accounts on each one of those. So again, this is why the date last active is extremely important, because this determines how long it can be on our credit reports. If the debt was discharged in a bankruptcy, the CRA may report it for up to 10 years. However, it's typically 7 years from the date last active. We know that to be true, okay? It says if the creditor didn't report the date of delinquency, they have two options. Option number one is they may establish and follow reasonable procedures to determine the date from the original creditor or another reliable source. Or if they can't determine the date, they may establish and follow reasonable procedures to ensure that the reported date of delinquency is the date before the account was referred to the collection or charged off. This is the FCRA 623A5B. And so if for some reason that information didn't get sent to them, they can determine that. But this is where it's important for you to look and to find that information so that you know the actual date last active. And it's different if Capital One has it on your account and you can see that first 30-day late was January of whatever year, and they're saying something different on this collection over here, then you know the information. They could have found it, right? And this is where, again, it gets into what are you going to do? How are you going to address this? This is what we help our clients do. So that's why we audit a file. We don't just go flimsy, okay? You have to know why something's being reported, how it's being reported, where is the information, and how should it be being reported. And that's where we go to work, okay? So that's extremely important to understand when it comes to delinquent accounts. So let's discuss disputes as well. When it comes to disputes, we as consumers have two ways we can dispute. We can either dispute something with the CRA or the credit reporting agency. And remember, there are more than just 3 credit reporting agencies. That's a tip. It's not just TransUnion, Equifax, and Experian. There are others out there, a lot of them who have information on us as well. And so CRA is any CRA, not just the big 3. We have the right to dispute information with them. You better know how to find it. The other way that we can dispute is to go directly to the furnisher. So let's see what they talk about when it comes to us as consumers disputing information. Now, if the credit reporting agency, that's where we decided to dispute first, they have to report it to the furnisher. And it states, if the CRA notifies the furnisher that a consumer disputes information they provided, they must investigate the dispute and review all relevant information provided by the CRA about dispute, report their findings to the CRA, provide corrected information to every CRA that received the information if your investigation shows the information is incomplete or inaccurate, and modify the information, delete it, or permanently block its reporting if the information turns out to be inaccurate or incomplete or can't be verified. They have to report their findings back to the credit reporting agencies. They have to provide the corrected information to all of the credit reporting agencies that they received the information from. So if you disputed the information with all 3, they have to report back to all 3. So if they report to all 3 and you only, for some reason, disputed it with TransUnion, they still have to report back to all 3 because that's where they gave the information or were reporting it to all 3. Okay. So it's their responsibility to update all of the credit reporting agencies if they find that information to be inaccurate or incomplete. Okay. And they must modify the information, delete it, or permanently block the information if that information turns out to be inaccurate, incomplete, or unverifiable. I love it. FCRA 623B1. Again, FCRA 623B1. And here's the kicker with it. They get 30 days. 30 days from the time that they receive that. So they receive it on whatever day, the 25th, then they have 30 days, get that information, do the investigation, get it back to the CRA. If they don't, it must be removed from the credit reporting agency. Now, that's where consumers get their information of, I'm just going to dispute this. And in hopes, I hope that they don't respond and then they're just going to remove it. While that is true, as we just read, that is not what credit restoration is all about. That is not making sure that they didn't follow criteria that we're reading through right now that they have to adhere to before they put that information on our reports. There are laws in place that protect us as consumers. It's not just about a wish and a prayer. This is about making sure your rights are protected. This is why we do what we do. So don't just throw something out there in hopes that they don't respond. Let's make sure that they are actually doing what they're supposed to be doing in the first place and protecting us as consumers, because if we don't hold them responsible, then they'll just continue to get away with it. Let's do it the right way and get this stuff removed or updated and get us focused back on where we're supposed to be. So when it comes to disputing with the furnisher, again, we have the right to go directly to the furnisher and dispute that information as well. So what must they do? They have to investigate it if it relates to the consumer's liability for a credit account or other debt with them. For example, disputes relating to whether there is or has been identity theft or fraud against the consumer, whether there is individual or joint liability on the account, or whether the consumer is an authorized user of the credit account. They must investigate if it relates to the terms of a credit account or other debt with them. For example, disputes relating to the type of account, principal balance, scheduled payment amount on an account, or the amount of the credit limit on an open-end account. They must investigate a consumer's dispute if it relates to the consumer's performance or other conduct concerning an account or other relationship, meaning disputes relating to current payment status, high balance, date a payment was made, amount of a payment made, or date an account was open or closed. Also, they must investigate a consumer credit report about an account or relationship with affects the consumer's credit worthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or lifestyle. This is the Furnisher Rule 660.4A. Absolutely unbelievable. Wow, I love it. They must conduct a reasonable investigation, review all relevant information provided by the consumer, and generally respond within 30 days. They also have to notify the CRAs that the information provided is inaccurate if that's what the investigation finds. However, they are not required to investigate a dispute if it relates to these things. So this is when they do not have to investigate, okay? So it's important to understand this. They do not have to investigate the dispute if it relates to the consumer's identifying information on a consumer report, including name, date of birth, social security number, phone number, or address. Why? Because we take that up with the consumer reporting agency. But the furnisher does not have to just do an investigation on that information, okay? They do not have to investigate it, the names of previous or current employers, inquiries or requests for consumer reports, information from public records, including judgments, bankruptcies, lien, information related to fraud alerts or active duty alerts, information provided to the CRA by another furnisher, of course. And so why? Again, because those are things we're going to dispute with the credit reporting agency, not with the furnisher, okay? They are also not required to investigate disputes that are frivolous or irrelevant, as defined by this rule. Let's read through it. The consumer did not provide enough information, the dispute is substantially the same as a dispute previously submitted. Don't send the same dispute twice. Find another reason. Did you see that second error on there? Okay. You already fulfilled your obligation. In this case, they already fulfilled their obligation and there is no new information. They are not required to investigate dispute as described from the list above. So, if a dispute is found to be frivolous or irrelevant, they must notify the consumer within five business days after making that determination. So if you send out a dispute on the 26th or whatever day, the 16th, and you get something back within 5 days that they marked it as frivolous, they do not have to do anything, okay? And it can be in letter form. So there you have it. There is a lot of more information where that came from, but those are some of the criteria that furnishers must adhere to when it comes to consumer reporting information on us as consumers. And these are laws. These aren't just suggestions. This is why it's extremely important to understand these laws, and this is what we do. Now, I hope you found this information to be extremely valuable and educational in understanding laws that they have to adhere to.